Hello. In this section, I'll return to the conversation on criminalization by thinking about two instances where a neutrally worded law has a specific impact on LGBT individuals. This will help us give an entry point into talking about discrimination, following which we look at the elements of two constitutional rights decisions that deal with expanding the framework of anti discrimination. The first of these broader laws concerns the regulation of sex work. Now, sex work in India is governed by the Immoral Trafficking Prevention Act of 1956. The Act does not theoretically criminalize sex work, but rather penalizes specific activities relating to commercial sex. So, Section 8 of the Act punishes solicitation, understood here as sex work drawing attention of potential customers from a visible, conspicuous site, whether in streets or private dwellings. The use and misuse of this provision has effectively resulted in criminalizing the existence of individuals as sex workers. As the People's Union for Civil Liberties, Karnataka, notes, police often proceed against sex workers without any evidence of solicitation and merely on the suspicion that they are sex workers. So, this produces an underclass of permanently targeted people who at any time are liable to be assaulted in public merely because they happen to be there, taken away to the police station, wrongfully confined and restrained there, subjected to humiliating treatment with their earnings taken away. The second broader law is the framework that criminalizes beggary. 20 states in the country have enacted their own anti-beggary legislation or adopted the legislation enacted by other states. A beggar, under this law, is any person other than a child who solicits or receives alms in a public place or enters any private premise for the same purpose. This purpose does not even have to be expressly stated. Under the law, even persons who have no visible means of subsistence and are found wandering in a public place such that it is likely that they solicit or receive alms are to be considered beggars. Both of these laws resonate with Section 377 in how they take a set of acts which are then used to construct a criminal figure. So there is a stereotype of this figure in the public imagination, and it is one that tends to align with a range of transgender communities that occupy a particularly visible kind of public presence. It's useful here to draw on the idea of intersectionality coined by Black feminist scholar Kimberly Crenshaw. What intersectionality shows us is how all aspects of social and political identities, may be gender, race, class, sexuality, disability, or caste discrimination, overlap or intersect. And so in this particular instance, your experience of a law or policy will be different from that of mine based on the set of identities you occupy. Taking into account the fact that livelihood options are drastically reduced for members of the transgender community through a range of structural factors, the resulting situation is the space where community members are disproportionately forced into subsisting through engagement in beggary and sex work. The ITPA, as it stood initially, was only applicable to women. With an amendment in 1986, the words female and girls were substituted by the word person throughout the Act, thus opening it up to target transgender and male sex workers as well. The PUCL report I mentioned earlier captures a number of testimonies of transgender sex workers who have faced state violence. In many instances, simply looking a certain way causes the police to scope out transgender persons on the street. The situation with beggary is often similar. In November 2014 in Karnataka, dozens of members of the transgender community were arbitrarily detained by the police at the Beggars Colony in Bangalore under the Karnataka Prohibition of Beggary Act 1975. Accounts note how most of them were merely going about their daily chores when they were arbitrarily arrested, aided in part by the overbroad definition of a beggar under the law, as anyone having no visible means of subsistence who is caught in any public place. Even as the criminalization of sex work continues across the board, it may be noted that the Delhi High Court in Harsh Mandar versus Union of India has struck down provisions of the Bombay Prevention of Beggary Act of 1959, which were extended to Delhi in 1960 as being unconstitutional. It recognized how criminalizing begging does not address the underlying problems. Instead, it, in ignorance of the realities of transgender persons, further marginalizes some of the most vulnerable persons. So the court also remarks that the state cannot escape its duty to provide for a decent life for all citizens by instead criminalizing those who are forced to beg for survival. The judgment has been lauded as allowing for protection of transgender persons from police harassment and inspiring similar challenges in other courts. In the case of both sex work and beggary, then, you have a criminal law that is facially neutral, but has a distinct impact on LGBT persons, particularly transgender persons, because of structural oppression that is linked to their identity. This is a useful point for us to move into thinking about a concept of discrimination which illuminates and expands upon some of these issues. I'll start with discussing the general scope of anti discrimination law before going on to talk about the two major constitutional developments in this regard. So, first, what is the scope of anti discrimination law? If we examine the range of actions usually understood to be discriminatory, direct discrimination is the most commonly understood and legislated upon. It entails unfavorable or less favorable treatment on the ground of a protected characteristic. Article 15(1) of the Constitution, for instance, prohibits discrimination on the basis of 5 enumerated grounds: religion, race, caste, sex, or place of birth. Indirect discrimination, referred to as disparate impact in the United States, involves a seemingly neutral practice or policy which puts persons belonging to a protected group at a particular disadvantage. If we understand 377 as an instance of a directly discriminatory law, then we might imagine the sex work and beggary laws in this section as an instance of indirect discrimination. So if we go back to look at the Nalsar and Navtej Johar decisions, both give us valuable tools that open out the scope of anti-discrimination law. In the Nalsar judgment, the court looked at the sex discrimination prohibitions under Article 15 and 16. The latter article looks at equality of opportunities for citizens in matters relating to state employment. Besides prohibiting discrimination on the ground of sex in public employment, the article also imposes a duty on the state to ensure that all citizens are treated equally in matters relating to employment and appointment by the state. The court holds that discrimination on the grounds of sex under both these articles includes discrimination on the grounds of gender identity. It reasons that constitution makers gave emphasis to the fundamental right against sex discrimination so as to prevent the direct or indirect attitude to treat people differently for reason of not being in conformity with stereotypical generalizations of binary genders. The court further noted that transgender persons were legally entitled and eligible to get the benefits afforded to socially and educationally backward classes under Article 15(4) as a remedial measure for the historic injustice dealt to the community. It also found that transgender persons were entitled to reservation in the matter of appointment, as envisaged under Article 16(4) of the Constitution. With Navtej Johar, a constitution bench of the Indian Supreme Court took these arguments further. Justice Chandrachud notes how stereotypes perpetrated by Section 377 violates the non-discrimination provision under Article 15 of the Constitution. Echoing a move made in Nalsar, but expanding the scope of the argument, the judge notes that discrimination will not survive constitutional scrutiny when it is grounded in and perpetuates stereotypes about a class constituted by the grounds prohibited in Article 15(1). So this opens out not just the category of sex under the article, but indeed all the other categories as well. As far as sex is concerned, the judgment finds Section 377 to be violative, since the law gives people ammunition to say, this is what a man is, by giving them a law which says, this is what a man is not. So laws that affect non-heterosexuals rest upon a normative stereotype. The bald conviction that certain behavior, for example, sex with women, is appropriate for members of one sex, but not for members of the other sex.